everyone. Welcome back. Welcome back after our break. You had a chance to have a rest. Now, taking over from Kat, I'm going to try to give you some examples which I hope will illustrate the trajectory of legal work of different kinds, not just working in a profit-making firm with which Kat is intimately familiar, but which is totally alien to me, but in a variety of fields like the community sector and the international sector, the government sector. Okay. So, as we've been discussing, we're looking at how it has changed over the past few decades, and also how it might change over the course of your legal career, which hopefully you'll be starting soon. A little bit more context following on from what Kath already introduced. The World Economic Forum, a think tank, published a report in 2016 called The Future of Jobs, and it said that 5 million jobs worldwide would be lost, okay, to AI, robotics, nanotech, and other disruptors in the coming, I think it was, I should have put on the slide, decade. Okay. So clearly we need to drill down into this a bit, but we start with the headline figure, so everyone goes, right. But taking a step back, let's focus on what has happened in the legal arena. Okay. As Kath mentioned, when many of us started, and this was the case for me, I started doing legal research in the late 1990s when I started my law degree in Sydney. And at that time, AustLII was only just being established. Okay. So before that, I was in the same situation of having to go to a library, and the library would have to subscribe to the right legal service published by Thompson, as it was known, or Law Book Company. And they had basically an agreement with certain courts to publish authorized reports. And sometimes there were other ways to get, like you could go to the court registry and request a copy of a judgment, but you'll see from the look on Kath's face that that was not fun. That was...
Or going to the ASX and getting the company records out.
Right, going to the land titles office. It is hard to describe just how much more time, how much more legwork was required to do the sort of research a law student or a junior lawyer needed to do than we have to do now. We could basically do it in our pajamas, right? As long as we've got some device in our hand. We can do pretty much everything that people would take, say, a week to do because the office was busy, you had to queue outside it. The law library, the one volume of the reports you needed had been borrowed by that annoying other student.
Or around exam time, remember people used to hide them. I went to Sydney.
Hidden books were a thing, believe it or not. I mean, to a certain extent, I do understand you still get that with textbooks because the publishers quite zealously guard the digital copies of those, and some of them are not as widely available. But most things now, like judgments and legislation in particular, are freely available online. And AustLII was a pioneer in the space. I don't know if you know, but AustLII was actually the first in the world to provide free access to the judgments of national courts and national legislation, and it quickly grew into the most comprehensive source of that in the world as well. Okay. Legislation.gov.au we have now, it's the Federal Register of Legislative Instruments, to give it its full title. Didn't exist, hadn't even been contemplated by the government, which was quite happy to sort of send you a copy of the Marriage Act or the Migration Act in a blue bound thing which issued from some printing office in Canberra. But online hadn't even been thought of. Okay? And Westlaw and LexisNexis also developed their products a bit after OSLI came along. It was, I would say, a democratization, okay, of Australian law. So really the reach, the law, like it was accessible now to anyone with an internet connection. And of course that does raise the other question of who had an internet connection in 1998. Not everyone, I'll grant you, but more people than had access to subscriptions to these law books. Okay? And Dr. Andrew Mowbray there, he's the director of OSLI, has been ever since that time. He taught me computer law at UTS in the late 90s. And along with Graham Greenleaf and another colleague, I neglected to put on the slide, called Philip Chong, they developed OSLI because they were some of the first people who had done combined computer, say, I think in Dr. Mowbray's case, comp sci law degrees, and they believed in the future, okay, of access to legal information. They believed it should be free and open, and online was the perfect, this new hypertext markup thing was the perfect way to share it with as many people as possible. And of course they needed an army of law students to enter data, where we came in. Okay. The other thing, apart from the reports, the law book company reports which I mentioned, were these things called loose leaf services. They still exist in a narrow sort of way. I believe Blackstone's commentaries are still updated as a loose leaf service, but it's maybe CCH. But it's really on the way out. You might find them in some of the older barristers' chambers still, and you get people, real people from the publishers, bring leaves, so a stack of pages, and put them into this little binder that's sort of bound like a book. And there used to be an army of these people who would come out to all the law firms, all the barristers, and update their loose leaf. Yeah, exactly. Okay.
The CCH, they still do that.
I believe
With
there's
the
still
CCH.
a couple. Yeah.
I've done it before.
But
I don't think they send people anymore.
yeah,
Oh, no, they
they,
just send
they
the-
probably just post it to you.
And they
now.
post it, yeah.
But even
not
that
the
seems
people, sorry, yeah.
even that seems quite
Oh,
antiquated,
I
doesn't
can
it?
believe
Even
it.
posting.
Yeah.
As they've been saying about this plebiscite in the news,
Mm.
what is post? Honestly, will it get there in time for the counting if I post it? Yeah.
Actually, I'm going to get the My Vote people to come to Tech Law. So they're the ones who are using some blockchain technology to allow people to vote on issues. They're trying to automate democracy. Yes.
Direct democracy.
Direct democracy.
Adam Jacoby?
So yeah, Adam Jacoby, yeah. He's insane.
Yeah.
He's completely insane, but it's a really interesting idea. Anyway, sorry.
Yeah. No, I mean, security has basically been the biggest worry of the AEC, which is a very conservative organisation, and hopefully blockchain will allow them to make some progress on that once Canberra gets its head around.
Just with
blockchain.
when you're talking just about OSLI before.
Yeah.
One of the things that some of you might be interested in is Victoria last year became the first Australian state and one of the first places in the world for the Victoria Report. So all of the official judgments from Victorian cases are now entirely online. So Jade, which is kind of like the successor to OSLI, I know a number of you use it, a company that's affiliated with them using their technology is doing the publication of all of the Victoria reports online now. So, and they're doing it on a fee, there's still a fee associated with it for like a pay-per-view though, as opposed to, so you don't have to buy all of the Victoria reports. You can just get the official judgment of the ones that you actually want. So, and I think that's going to really actually put a bit of a kick up the bum of AGLC as well, because they're going to have to really adapt the way that they deal with referencing to take into account the fact that so much is happening online.
I
There's
don't know if
no
you've noticed-
actual AGLC for Twitter, for example, and
Wow.
everything you quote Donald Trump on has to have a Twitter hashtag, right?
I don't know if you've noticed, but AGLC doesn't even let you give the online citation for a High Court
No.
case, although the High Court has been happy for you to use that for years.
Yep.
AGLC used the CLRs,
Mm.
where you have to go, I think it's, or was it Westlaw?
Westlaw.
Westlaw.
Yeah, it's whoever the
That's the only authorised reports, right? So previously, you had to get the paper. You still have to go through Westlaw, which I find to be one of these overly complex, meets the needs of someone out there, but more than most of us humble lawyers. And Ostley, we now, I think, we trust to give us very good reproductions of judgments, and they come directly from courts and so on, but they're not the authorised reports. Okay? You can't cite like an Ostley link or something. If you actually are writing a scholarly article, PhD or something, you have to make sure that all High Court citations, quotes and so on, come from the CLR with a page number. So from a PDF, not even the... Anyway, by the by. All right, sorry.
The
was there a
reason I
question?
haven't done a PhD.
I had to do that at the end. I had all the online stuff. Anyway, nightmare. All right. In my line of work, I did spend a few months working in domestic law in the Attorney General's Department before I moved to the Office of International Law, and quickly found that now I had to learn a whole new set of legal research skills because I hadn't learned the international law researching as an undergraduate. Okay. Now the UN, most of the things I needed were contained in the jurisprudence of, for example, the Human Rights Committee or the Committee Against Torture. These are the oversight bodies, for those who benefit of you who haven't studied human rights law, of the international human rights treaties to which Australia is party. Okay? So that was the sort of thing I was advising the government on, and I needed to be able to research this jurisprudence. But the UN didn't come to the party with searchable jurisprudence until 2015. Okay? I started there in 2007. So way, way before. So there was this Netherlands Institute of Human Rights, known as SIM, and a single US professor called Anne Baevsky, who maintained websites which they don't look like some of the fancy tools we have today. They weren't, didn't have the kind of search power of Jade. They were mostly more like Ostley with, links to things and tree menus on the side. But that was a godsend for someone researching international law. Before they came along, it was even harder than researching domestic law because most of the books you needed weren't even they certainly weren't in the Attorney General's Department's library. You had to request some from overseas. You had to rely on citations, sometimes in textbooks. Anyone? These sorts of pioneering online resources, often done by just a couple of people at universities, are the precursors of the tools we have today, and just represented this massive opening and democratization of access to law, which for me, I was lucky because I was sort of on the cusp of it as a law student, but before it, I think lawyers' jobs were very different. They involved a lot more time spent in libraries or requesting and waiting for resources. And now, the usual problem I find is that you have too much information. Okay? So you'll be asked to research some legal problem, advise the government on some issue it has with, boat arrivals. And there will be thousands and thousands of judgments and opinions, and you can get comparative jurisprudence. It's not just international law you can find. You might be able to find what like-minded countries, as they call them at DFAT, have done. Canada, New Zealand, all sorts of things right from your desk. other areas of international law are still don't have searchable databases though, like the human rights one. And the human rights, the juris.ohchr, Office of the High Commissioner for Human Rights, actually just took all the data from SIM. SIM willingly handed it over once the UN was kind of ready to make this leap into the online world. But many other things like trade decisions and so on and so forth, they're harder to find than the human rights ones. Just something to note, it moves very slowly. Okay. So Oxford has this thing called the Future of Humanity Institute. The sort of people who give a lot of TED Talks, I don't know if you've come across them, but they polled AI researchers, so they figured the people who are most likely to be able to make accurate predictions on these things, when they think their products, their algorithms, their digital friends are likely to be able to do certain jobs. Now, I know this is too hard to read, I'm sorry about that, but you'll be able to see it when you get the slide for yourself. Full automation of all human jobs, they think it's doable in about 120 years. That's okay, it's well into the future. Surgeon, about 30 years. Yeah, well, we already see sort of robots doing manual tasks. Right, New York Times bestseller, also in the sort of 20 to 30 year range, they predict. You'll note down here, actually, they've got write high school essay. That should be possible in less than 10 years. And I thought a bit patronisingly, write children's book, which is a lot harder than it appears, is somewhere down there at, what was it? Sorry, I can't see it now, but anyway, it was in their survey and it was down there and even less than 10 years. But
I'm surprised Top 40 pop song hasn't been done already.
yeah, Top 40 pop song.
Sure.
Sort of,
Wasn't Stock Aitken and Walkman, wasn't that actually a program?
I think, yeah, somebody that Friday song was a thing. But the one there's a couple I find interesting, and that's an AI researcher. They think they'll be able to replicate their own job within about 80 years. That means the AIs will be programming the AIs. Maybe that's when we'll get rid of the coder bias. Okay? Yeah, basically that's the singularity right there. Don't worry about
They won't need us.
the point after that. What about us? I think maybe New York Times bestseller, somewhere in there, maybe between there and All Human Tasks. I guess that's where they're saying the lawyers will be completely replaced. However, there's a lot of little steps on the way to complete replacement, of course. And as Cass mentioned, not everything a lawyer does requires those high-level strategic or tactical skills. So these, I think, are some of these first steps. For example, some Cambridge University students, led by this guy called Ludwig Bull, they created something called LawBot in 2016, Facebook Messenger chatbot to answer people's basic legal questions. Okay, drawing on a big, you would presume, very big data set, okay, and just focusing on the criminal law to begin with to contain the data set that they had to use. Of course, if you have a really, really huge data set, you need massive computing power behind it to be able to answer people's questions in a reasonable time. So, relatively modest beginning. It was supposed to be able to answer these common legal questions like, you know, is it an offence to punch my neighbour, sort of thing. Which offence is it? What sort of prison time am I up for? But that was only a year ago. It's since been, they've renamed it Elixir. They're planning to raise £5 million by creating their own cryptocurrency. And they want to do that because they've seen so many startups be either bought out or effectively taken over by venture capitalists, that they want to maintain their independence. And they've issued a challenge to, they say, some of the best lawyers in London, which means the best lawyers in the world, as we know, to predict the outcomes of legal problems, this time not confined to criminal ones, with known answers. So basically, decided cases, they'll just have the factual scenario and sort of the legal question, and they'll pit their bot against a lawyer, like the scenario that Kath described, except instead of a first-year paralegal, who was the poor Patsy. It's horrible, isn't it?
It was really
And the
unfair.
Yeah. And
It was very unfair.
it's also, arguable, like,
And they did it in a room above a pub too, which I thought was kind of funny, but anyway.
right. So this one's supposed to be against top-level lawyers. They haven't actually held this competition yet. We'll see. But what they talk about is the moment when IBM's Watson challenged the best people and got down to one person at Jeopardy and won, which everyone said was this defining moment, seminal moment in the development of AI. If you can beat humans at tasks that humans want to be good at, well, it's a pretty good day for an AI researcher, isn't it?
There's a tool that it's actually sadly just been bought by LexisNexis, which I think will be the end of it, but a tool in the States called Raggle, which basically is an AI tool that sits over these massive databases. And one of the things it's being used by with law firms is it will, once you know what judge you're bringing a matter before, it will basically do analysis of the different lines of arguments to come up with a prediction of which line of argument is more likely to persuade this judge based on previous materials, including actually writing styles. So it will do analysis of the briefs that have been filed in front of this judge and rate them for success, and then basically go back and edit your brief for you to, change from active to passive.
Can you imagine how many people had that knowledge before?
Well, they were the
A
SCs,
few
right?
senior
The
litigators.
QCs. That's what we pay.
That
That's what we
was-
pay the big bucks for. Usually, is the tactical stuff. The thing the QC knows
That earns them $10,000
as a day because they know this particular judge is more like and it's so simple. It's really fascinating what they can do.
Watch the show The Good Fight, which is the sequel to The Good Wife. But last week they had it, and they had the law firm. They had someone, like one of their benefactors, had a computer and them typing the case, and the judge, and come up with the success rate, and that will determine whether they would invest money in that case.
Yeah, well, in fact, that's what they use Rabble for as well. Is part and that comes out of some of that Watson technology as well, which, it's actually really interesting to see work. That's why I think that 13% is such a ridiculous number.
So they're also, being a cocky startup, looking to expand into other areas and monetize everything. They're offering client leads to firms using basically a Tinder-style algorithm. They're matchmaking clients to firms, swipe left on a client, because they say that, they correctly say that large firms have a client profile problem. Okay? Most of their clients are over 50, and I guess any business would be like, oh, well, that's going to be an increasing problem as time goes by. And to, put it in marketing terms, attract a youth demographic, they're talking about using these algorithms and letting the clients basically register like you would for all sorts of other things like Tinder and other services, Domain, all these ones where they match you to the service providers without you having to go out and look for them, which young people like. And the law firms find that that's an avenue for attracting clients with money, but not a habit of using firms. Okay? And also a service that analyzes the chance of winning cases, like that Ravel service from the US. So closer to home, we've got something called finefixer.org.au, which is relatively new. I don't know if any of you have heard of it or used it, but a very similar idea based on sort of chat response, sort of suggestion response interface. And it was a collaboration between the Moonee Valley Legal Service and some RMIT students. You can put in the circumstances of a fine you've received, which you want to challenge, and it can sort of tell you how you might challenge it, if it's likely to be challengeable, all these sorts of things. These are the sorts of questions which swamp some community legal centres, okay? Receiving fines and infringements generates thousands, if not the bulk, of the legal problems that people bring to some community legal centres. So they can also lead to very serious consequences. I don't know the link there that you'll be able to click on when you get the slides is to the case of Miss Dew. I don't know if any of you have seen it in the news. It's an emblematic case, and it's a case in which the worst possible outcome eventuated. But this woman, she was locked up for, I think, failure to pay about $3,500 worth of fines in WA. And she eventually lost her life in prison. Okay. So, lost her life over these unpaid fines, which were all for minor infringements, collection of fines. And imprisonment for unpaid fines is actually, it continues, especially in WA and the Northern Territory, to be a massive problem. A lot of people in those jurisdictions are imprisoned for unpaid fines, and something like this might well be a way, other than, hoping for a policy change is also a good thing, and advocating it, but something like this might be a way to use technology to reduce some of that, yeah?
In that community in particular, one of the things I type often is people are being sentenced by fines, which of course it's impossible for them to pay.
Right.
And then also having their licence suspended if it's a driving offence,
yeah.
which
and so
makes
you can't
them
earn
unable
money.
to get to work, or then being ordered to perform certain community service.
Yeah.
And it's the legal system itself kind of perpetuating a horrible cycle. And the worst thing about this Do case is that the police were called because she was the victim of a domestic assault, which is why she died in custody. So it's the system itself.
Absolutely, yeah. The injustice is off
mess.
the scale.
Yeah, so the fines itself is...
So it might interest
It's
you.
not even fines you can avoid because it's court ordered.
Right.
About
So
that frustration.
it's a sentence to the fine, and then
And it costs the taxpayer more than $3,500.
imprisoning someone
in the first
is
place. So it's
like
like
$100,000 a
and-
year.
A lot of
like
that,
the system.
the number is actually, it's the first fine, which, and particularly with domestic violence victims, actually usually the fine relates to an offence committed by somebody else in a vehicle registered in their name. I don't know if that was the case in this, but there's been a lot of issues with domestic violence victims who end up with, so then the first fine, they either don't know about it, particularly if there are literacy problems, which there are in Indigenous communities, they don't know what to do, and then you end up with a fine, and it just...
Many domestic violence scenarios too lead to one of the people involved being financially abused. So even if they had a certain amount of their own money, if they're being abused by somebody who's taking all the money and then using it on grog or using it on pot or whatever it is, then they don't have capacity, even if they had capacity on paper. So it's anyway.
And it's,
Sorry,
yeah,
that's
it's,
off the topic.
but the thing is, it's not off the topic in the sense that looking at ways, I mean, what's a lawyer for?
Yeah.
What is the lawyer for? And if we ask ourselves that question and we think about those kind of problems, are they problems we want lawyers to be solving, or are they, like on an ongoing basis, or are they problems that we should be using our collective intellectual and goodwill might plus some technology to solve so they don't keep happening.
Or that lawyers then use their people skills as opposed to just putting a case before the judge and saying, oh, well, obviously, you know, my client has to be in prison this time. If what you're left with out of the lawyer's set of skills is people skills, then what I hear a lot in court when I type is that there's a lot of people skills that can't be applied because the law is rigid as well. So you'll have a judge who's looking at somebody saying, I know
if I
that
had
you-
discretion in this case, but I don't.
Yeah, and I actually heard a judge, and I can say it because I'm saying it anonymously, but say the sentence to a self-represented person whose lawyer had to leave. So they're having this direct chat about him having to sentence him, and he said, sentencing isn't about what works. And that came out of the judge's mouth, and he was saying it compassionately. It's like sentencing isn't about just doing what works. It's about all these other expectations and blah, blah, blah. So yeah, if what you're left with is a fine which has to be paid, and
You
that
know,
problem
in the
will
back of the
solved.
judge's mind now, do you know what else he or she is? Herald's son. They do not stop hectoring the judges on
And he didn't have
appropriate
discretion in this case.
sentences.
Like, it was one where he had to.
And sometimes there are
mandatory
mandatory minimum sentences, which is the case in, coincidentally, WA. and on the church. One thing I'll just mention, which is, again, a tangent, but relevant, I think, and a bit disruptive, it could be a disruptive idea in Australia as well, is the idea of fines being indexed to the person's capacity to pay. Okay? And frankly, I think it's outrageous that people in Australia get the same fine for the same offence regardless of their capacity to pay. So if speeding 5 kilometres over the limit is exactly the same for an unemployed person as it is for a CEO of a bank. Anyway.
I think it's
We could go
ridiculous
into
that you
this.
can get a fine for going on like a tollway, which the government doesn't even own, and then end up in prison for not
It's like,
paying that fine.
it's like there are some gazetted places where you can get a government fine for parking in private parking in. All right, look, we could go on all day, but the point is that many of these things are intractable policy problems which people, like community lawyers, have been advocating for many years to change, right? But which have not changed for various political reasons, and perhaps technological disruptions and might provide us with ways to work around these policy blocks, which have sometimes terrible consequences. Okay? Also, another quick example, powered by Watson, which IBM sort of donated for this purpose, was one called Do Not Pay. Did a similar thing in the US, available in all 50 states. Similar service.
Is that the one where it writes a letter to the...
Generates a letter for, I
Yeah.
think, Fine Fixer can
I think that's one of the,
generate a letter for you
yeah,
as
it'll
well.
generate a letter and
Yeah.
it provides you through the
That's right,
steps.
yeah. All right, so hackathons, okay, obviously a neologism. Law firms, I mean, obviously coders had hackathons long before it was cool, but law firms have now embraced this idea. For example, Gilbert and Tobin, cooperating with Westpac, had one in February 2017. I think they had another one in 2016. In the UK, Alan Novery are big supporters of legal hackathons. I've got a link behind that Gilbert and Tobin entry on the slide, which has sort of glimpse into their most recent hackathon and shows how lawyers at all levels in the firm, but mainly junior ones, it has to be said, are split into teams, and they're doing sort of brainstorming sessions, but to develop new ways to solve problems, to make more efficient processes which go on in the firm every day. And they're competing, these teams, I think it's over 24 hours. It's quite
Usually, yeah.
a bit. And then the partners will judge, which of them has produced. Do you want to?
Well, it's funny.
describe this
It's
further?
interesting because I have a bit of a mixed view on this. I do wonder to what extent the hackathon is sort of the cool new way of essentially having a kind of, what do they call it when you join a hazing kind of process? It's like 24 hours, give them lots of caffeine, don't, keep them
It's a little bit
inside
Hunger
and
Games,
pit
I
them
have to
against each
say.
other.
Like, they don't look too good after the
So
24
that
hours.
I'm a bit funny about the ones that law firms themselves are doing, and I've actually facilitated an internal one for a law firm once, and I must admit I felt a bit dirty. It was only an afternoon. The Westpac one, I'm not sure if it's the same one you were talking about. I didn't look at the link before, but so Westpac itself runs a hackathon and invites its service providers to basically pitch. And I know, so there were 4 law firms who participated in the 2016 one, and Gilbert and Tobin, Hall and Wilcox, I want to say Allens, but I think I'm wrong, and another small firm were the only ones out of the whole of the Westpac panel. So only 4 law firms put their hand up to do it. And I think an element of that was, it was very public that they had a particular problem. It's interesting though, Hall and Wilcox actually won that first Westpac hackathon thing. But G&T are the firm that have really sort of pushed and told the world about what they did. But as far as I know, I don't know about the 2017 one. Hall and Wilcox are the only firm that have ended up out of that kind of Hunger Games experience, getting sort of ongoing billable work through it. But hackathons are really just intense problem solving events. So traditionally they're about developing an app or doing something like that for that purpose, but really they can be any kind of problem solving. And so the design thinkers really like them, because it's really about doing this sort of divergent thinking exercise of really understanding the problem, doing a lot of deep research, and then coming straight back into really converging again to get a solution.
Which, if I take off my cynical hat about big firms trying to short circuit their own fee generating processes, it does kind of give junior lawyers some space to do some thinking that they might not otherwise have time to do, because they're too busy doing whatever the partner is assigned on one single problem for a long time. Anyway, must keep moving, get done. In terms of online courts, I think Kath already mentioned that the equivalent of the ACCC, the VCAT. So for claims under 25,000 Canadian, can all be done completely online. So there's there's not a registry.
They have no physical court.
Right.
So they're very much, and again, they started with asking the question, what is a court? Is it a place or is it a service? And actually that's a question I don't think I ever really asked myself until quite recently. Like, what is a court? Like, we're talking about the courthouse, or are you talking about the service the court provides? Does it need to be physically located somewhere? And so they have, in fact, their staff, I know the CEO is based in Vancouver, I've spoken to her a couple of times, but I think their staff is across the whole of Canada, basically. They don't have a physical location.
I mean, that's
but they've
well ahead of anything that we do have e-lodgement and so on, but I think it'll take several years for Australia to get to that point. But I don't doubt that will happen, because the efficiencies which it can bring, and the familiarity that incoming lawyers will have with this sort of online cooperation and so on, will mean that people who are making the policy decisions about whether to establish a new court as a $20 million building or as an almost free virtual presence will feel much more comfortable with choosing the latter than the people who are making the decisions now. Okay. There's this UK startup called Legal Geek, which organised another of these hackathons to create concepts for online courts in the UK. And the reason I highlight this one, amongst many sorts of similar things that are going on, is that it had the cooperation of the Society for Computers and Law, run by Professor Susskind, the Ministry of Justice, and the courts of England and Wales. So even the Lord Chief Justice turned up to this hackathon. Okay, the G&T sent a team, probably with its marketing budget. So, again, I just can't see the Chief Justice here yet, maybe in several years' time, participating in something like this. It just feels
I don't know,
like
actually.
maybe the current Chief Justice more likely than the previous ones,
Yeah,
actually.
well,
but-
look, I don't know enough about Justice Keufel's approach, but Marilyn Warren, who's about to
Well, the
retire,
Victorian courts are
has been
different.
She really came with a mandate to modernise the court, and the reality is there's no votes in renovating the courthouse. The Supreme Court is a beautiful building, it's an amazing space. But again, I think she comes to it very much from the point of view of the court as a service, and did think about the court from a business plan perspective.
Well, authorising
really-
online reports is
Authorising-
revolutionary in the Australian context.
Yeah, I mean, it's sort of, a very boring revolution in its own way, but a revolution nonetheless.
Yeah.
And, part of what she needed to do, and, she's about to retire now, she's been around for, 15 years or so, possibly not even that. Rob Hulls was the Attorney General who appointed her. But at that time, so she said, well, what's this court for? Coming in as the boss, first woman, and at the time the second youngest in terms of years on the bench in the court when she came in, in a very hierarchical environment, saying, okay, at the end of the day, we do commercial disputes. Commercial people can pretty much pick their forum if they want to, right? So we need to focus on commercial disputes, which means we need to make it easy and convenient for people, which means we need to modernise our computer services. We need to have, so stuff like, one of the things the Supreme Court, I don't know if you know, they're really proud of, was some dispute a few years ago to do with the Grand Prix and whether somebody could race or not race. Does anybody remember this?
Yeah.
And they basically had a hearing in days, and we took evidence from all around the world with these electronic, they basically set up a courtroom to do that. Now there are no votes in renovating the Supreme Court building, right? There are no votes in making prisons better buildings either. You go and work in the courts, and a few of you doing internships, you will see just how under-resourced they are. But thinking about how the court can deliver its services using electronic, I actually think, I'm a big fan of Marilyn Warren's at the moment. She's done some pretty good stuff in her last couple of months, but that in particular I think is visionary.
So speaking of visionaries,
We need to move forward, and I've got to stop talking, sorry.
Justice Kirby has been calling for the modernisation of Australian courts for a long time, and Kath already mentioned that the ABC did an interview where he's calling for online civil courts. He also thought that online criminal courts should be fine, because he did not believe that judges would base people based on whether they're wearing prison greens or makeup or whatever. But for a start, at least like the Canadian situation where civil courts where the claims are up to a certain size should be eminently achievable. Okay. In government legal practice, I just thought I'd do a quick overview of some changes which have happened and are happening. So the Australian government solicitor over the last 20 or perhaps 25 years actually went from being inside the Attorney General's department and doing billable hours to being outside the Attorney General's department and not doing billable hours. That was probably the best time to work there, to be honest. And now it's been reabsorbed into the Attorney General's department. Some of these changes in Canberra, I mean, the new Home Affairs department they've just announced boggles my mind at the sheer cost in administration of merging departments like that. Because even bringing the government solicitor, which had its own separate building in Canberra and all the admin associated with that, back into the Attorney General's department, to my mind, was a huge and unnecessary thing to do, but it was decided at a high level that that was the best thing. Government lawyers now need, and I think it's covered in which topic? Anyway, I'll get back to you on that. But practicing certificate requirements have changed since the Uniform Law came in, and now government lawyers providing legal advice, even if it's exclusively to government, need practicing certificates and have to fulfil their CPD requirements. It doesn't apply to legal policy officers. So I went in my Attorney General's job from giving legal policy advice for the first 6 months or so to giving actual signed legal advice. Though I'm not sure how the practicing certificate deals with giving international law advice. I would probably need a practicing certificate if I were to start that job today. Okay. The other thing, I know this is a very brief overview and I apologise, and I'm happy to take questions on this after the class, but government lawyers are facing ever-growing restraints on what they can say publicly in an age when everyone else is saying more and more publicly, right? On their Facebook page, on their Twitter, anything you post on social media as a public servant could get you fired at a moment's notice. You could be fired the same day for a slip-up on Twitter, and people have been.
But that's the same.
Yeah, I mean, some firms have really strict social media policies, but I think the material difference, as far as I'm concerned, is that policy is usually, like, if you say something outrageous which would bring the firm into disrepute or something like this. This is just if you disagree with current government policy. But I think is a real freedom of political communication issue. Okay.
There's a big post about it that came out on the 7th of this month about the changes.
Yeah, so the Australian made a really big deal and said massive new social media policy for public servants, but then the Australian Public Service Commission, which I'm sure none of you will ever have heard of because no one ever listens to it, came out and said, actually, we haven't changed any of the rules, we've just made the policy, paraphrasing, we've just made the policy sound harsher. So the Australian thought it was a whole new social media policy, but actually they just sort of phrased it in more cautionary language. The rules are still the same for public servants as they have been for the last few years. Having said that, they are quite harsh, okay? I mean, sorry, did you?
Yeah, but, I mean, when you're a government worker, there's this,
Yeah.
you have to be non-biased and
Right, you have a
non-political. It's like part of your
obligation to give
Yeah.
impartial advice, carry out the wishes of the government of the day. Absolutely. So there has to be a line, and it's open to us to say perhaps they're drawing the line in the right place here. But I just wanted to highlight the tension between sort of freedom that most of us feel to express ourselves online with what you might face if you become government lawyer.
I mean, as an example here, a lot of social media conversation over the last couple of days has been about plebiscite. And 80% of the country approximately has a particular view, and that would make you think that roughly 20% would have a different view from that. Most people seem to be quite binary. To me, it seems ridiculous that if I worked for the government, I couldn't express my view that is consistent with 80% as an
Even if you
education.
worked on, say, fisheries,
Yes.
or
So I'm
The ABC just put out a thing saying that none of their employees
even if you
are
worked
allowed
for the
to.
ABC.
And I thought the ABC would have had some places in which they, you have an editorial, so all these other papers, like the Daily Mail, could have an editorial.
Well, they cancelled the drum online. They're really trying to wind back. When I say they, I mean the new ABC board are trying to wind back the ABC's editorial content.
At all. And yet
I mean,
you
they do
go-
have some.
And then you get Barry Cassidy, who's amazing, and you need editorial content that's analytical and good. And the Daily Mail's still free to have its editorial.
Anyway, an
And
endless
judges,
debate.
As a public servant, judges
Absolutely.
are always
yeah.
called, and yet they've got very obvious politics. So you've got Hayden saying, "No, I'm not going to be biased." You've got all those kind of things going on all the time.
Anyway.
Oh, yeah. And it's a different philosophical argument to an extent, but it is worth remembering that the practice of law doesn't happen in a vacuum. At one level, judges are for putting all that bias in their background and dealing with applying the facts to the law and the circumstances. You know, that's the methodology that the common law has adapted over time. But nothing's ever happening in a complete vacuum. And you know, I don't know, when you've got, let's face it, the President of the US tweeting policy left, right and centre, why someone who works for fisheries can't come out and say that they'd like to marry their partner.
There appear to be different rules for the people at the top. It came out today that Malcolm Turnbull had been using his private email server to conduct sensitive things like counter-terrorism operations, directed and things like that. You know, things for which a public servant would be so fast you wouldn't see which way you'd been pushed.
What happened to Hillary?
Anyway, we could go on and on. So, speaking of Mr. Turnbull, he goes on about agility and innovation, and since he is communications opposition spokesman, been pushing this sort of digital transformation in Canberra. Okay, so when early in his tenure as PM, he set up this digital transformation office under a guy called Paul Shetler, and he came in with his sneakers allegedly, although he claims he didn't really wear sneakers to meetings, and tried to shake up the public service to get it to deliver, like it was this whole .gov.au push, right? So we ended up actually with MyGov, which wasn't exactly what he had envisioned, but he wanted the government, some data and all the things, all the back end, to basically sort of provide him what he needed to produce a pretty accessible front end, like some other countries have. Okay? He had established a similar thing for the Ministry of Justice in the UK. But he found he actually couldn't work with Canberra Public Service on this. They weren't willing to change as fast as he would want, perhaps, and basically just sort of pushed him out. The story linked there says that Angus Young, who's a minister, I think assistant minister in the current government, has sort of taken over the digital agenda and wants to move much more cautiously and slowly. Okay. Of course, there is, again, like with the social media policy, another point of view. The obligations of proper public service, following procedures, making sure that huge shifts in the way services are delivered don't disrupt those services. Census, anyone? Maybe they had a point. Maybe when Australian government at least, tries to rush in when it comes to digital things, like if we tried to do digital voting too soon, we would stuff it up.
It's because we cheap out on it.
Yeah, I mean, that's the thing.
And don't forget we have legacy technologies too. So Latvia is deploying blockchain technologies. So for a whole range of government services. So all of your medical records in Latvia are online, in the cloud, outside of Latvia actually, but there's blockchain, basically channels to get there. All property, so we use a Torrens title system, all their property records are held on the blockchain, a range of different things.
Did you know that the Victorian government wants to sell all our property titles to a private company, which probably won't use blockchain?
But you think about that kind of situation though, what's Latvia got that we don't have? It's a new country, it started with an absolute clean slate. Secondly, what else does it have? It has the fast food, but it also has the threat. Latvians are really scared that the Russians are going to invade, right? So you've been in a situation where actually your whole country could be in turmoil. It actually makes sense for all your property records to be somewhere where they're not going to have the shit bombed out of them, to use a technical legal expression.
And in a less sort of physical sense, some of the best defensive hackers in the world live in Latvia and Ukraine, also because of Russia, where the best offensive hackers in the world live.
But then you make some inquiries about how much money Australia is spending on offensive cyber capabilities, and yeah, that's something I suspect we need a bigger conversation about, but not in this class.
Anywho, I'll
I
try
have another
to
class
wrap it
there.
up. Sorry, I know it's
No, that's me.
Now, community legal centres, we've discussed. Obviously, funding is one of their main limits. We were talking about this when you were doing that business plan. Resources, of course, like Ostley and now Jade, of course, have made it easier because they didn't have to subscribe to expensive legal resource services. Legal aid, again, a slightly different category, but has to turn away thousands of people who would like to avail themselves of its services, tighten its eligibility rules every couple of years as funding sort of doesn't keep up with inflation, and doing more for less, which is one of Susskind's sort of catch cries, which he usually is talking about law firms, I think has a particular resonance for legal aid and community legal centres who have to do a huge amount with next to no resources. So these sorts of technological aids can make a proportionally bigger difference in that sector. Okay. Now, just to follow on that topic of the Suskins, and Daniel is Professor Richard's son, they wrote a new book in 2015 making some more predictions, maybe updating their predictions for the professions, including the legal profession. And they're saying that all the professions, and especially the legal profession, will change more over the next 20 years than it has in the previous 200. Okay. They actually say in their book that Dickens would still recognise the way that a lot of the work is done in modern legal firms. Okay? Not all of it, they have computers now, but some of the things are still done the way they were hundreds of years ago. I just wanted to highlight a few of the passages from that newer book. So the greatest pressure on that approach is cost. Okay, so the cost of doing things in that sustaining kind of way, it has been increasing over time. Wages becoming more expensive, buildings, rent, all those sorts of things, subscriptions to legal services, sometimes going up faster than inflation, way faster. All the people providing those services are seeking to maximise their profits as well, of course. And as a result, and this is something that former Justice Kirby highlights in that interview that's linked on the other slide, most legal and court services have become unaffordable to most people who would like to use them. Justice Kirby calls our system the Rolls-Royce system. Perhaps showing his vintage a little bit, but you can still get.
Written in the back of an old Rolls Royce, like the suspension's not that good.
No, they're not great. But you can still get a BMW made Rolls Royce, very nice, very expensive. You get sparkly sky, a special Chinese option. Sorry, it's only available in China. That's why I say that. Not for any other reason. It's a special. I watched a documentary on it. Okay. Whew. Anyway, so things being automated, like there was that list on Kath's slides, document review, due diligence, contract drafting or parsing, and by parsing I mean digesting huge contracts just to find that clause that your client's really interested in or which might catch your firm out. Rudimentary, they say, legal research. So at the moment, the sort of legal research which can be automated is not terribly sophisticated by the standards of like a full-blown solicitor, but it might be approaching the sort of legal research that can be done by a paralegal. Means by rudimentary. Virtual courts and online dispute resolution are fundamental challenges to the courts. Okay, so as Kath mentioned, the Supreme Court is now sitting there going, well, what if these commercial players just don't use us? Okay, they have a choice of venue because they're not really tied to anything. They can settle their dispute on the internet.
So we all know, because you have an excellent contract law teacher, most of you, that you cannot actually contract out of the legal system. So we know that you have to, you can't actually avoid going to court if the other party wants you to. But at the end of the day, you can actually set a mechanism for solving your disputes.
Right,
And
if you
more
both decide not to go
disputes-
to court. Yeah.
More disputes are solved on Modria than anywhere else internationally. And that's just basically some software that eBay built so that it didn't have to put people in between problems that people had on eBay when eBay sales went wrong. And now it just pushes out onto a whole heap of other things.
Yeah.
Very
Online
interesting.
dispute resolution is shifting focus away to like really quick sort of almost dispute avoidance rather than dispute
And again,
resolution.
think about value proposition for going to a court. What do your clients want? They don't, well, some of them do want their day in court, there's no doubt about it. They're actually few and far between. They want to solve their problem.
Yep.
Sorry,
Yeah.
we
No, I mean,
right at the end.
clearly
so
there are
I'm
other
just-
categories of cases where
Yeah.
it's more appropriate to have an actual in-court litigation, but for many, if not most claims, alternative systems might be appropriate. Something which strikes fear into the heart of teachers, especially in the US, but it's a growing thing here, ratemyteacher.com. There's an equivalent in the US now for lawyers, avo.com. Sounds a bit odd to Australians, obviously, but to these, avocat being lawyer in French, you can go on there, and there's like a picture of the lawyer, 4.5 stars, would use again. It's probably coming here sooner rather
Geez, I
than
heard
later.
of Avo and not Rate My Teacher. Now I'm going to have to go and Google that.
Yeah,
Don't.
no,
Okay.
my advice is not to. So, finally, some implications for regulation. What if, and this is just something for you to think about, I won't talk too much about it, so it's getting late. What if a law service, an AI-driven service, something cloud-based, somehow leaks confidential information? We're going to talk a lot about confidential information in this subject. No one can be held responsible because of, I don't know, chain of custody, some reason it doesn't fit into the current rules. What then? Just update the rules, you say. How long did it take to get the uniform law adopted? The answer is a very long time. So just update the rules may not be an adequate answer, especially if the technology keeps changing and changing and changing. What about the Uber disruption? Okay, so an example behind that link is that Transport for London just completely had no idea what to do when Uber came in, kind of just let it happen. In fact, that happened in, I would say, most cities where Uber came in.
That's why we call it a disruptive business model.
Right, but the legal regulator in the UK is thinking about this and trying to plan for the possibility. What would it do if some service just tried to bypass the courts, ignored the law? Uber isn't really seen as civil disobedience, but arguably it is, isn't it? And I'd like you to think of other scenarios where the regulation is going to just be far outstripped by the pace of some of these disruptions that we've mentioned and what it might mean. Okay, and just a link to some of the things I mentioned and some resources and that Deloitte report.
I have a personal opinion about Deloitte that came out there, so yeah. Don't listen to me.
It's far from compulsory reading, I must.
A good report, actually, for really should take.
At least have a think about that graph where they say that 60% of our economy is likely to be disrupted soon. And I recommend the Siskin books as well. All right, thanks very much, everyone.